大家好，我是曾博荣律师，我也是阿凯迪亚的副市长。谢谢你来我的频道，律师怎么说？我发觉说，华人经常来美国的时候，有很多的问题，其实他们都一直在脑海里面，不知道怎么答复。所以我希望说，我们这个频道可以帮助我们的华人。谢谢。Hello, my name is Paul Cheng, and I'm back. I know previously we did a small lecture on wrongful termination, and I have another section related to employment law called hire to fire. And really, I give this lecture to many of my clients as well as businesses across Southern California in regard to from hiring an employee all the way to firing an employee, what are the best practices that are available to the employer, and the best practices when an employee feels wrong, they can be able to speak to an attorney about. Now, best practices in and of itself is not, I repeat, it's not really a legal term. The term really is about how an employer and employee relationship should be, apart from the law. And I'm going to explain to you how if you use best practices in your own business, you'll be able to do things in a much better way. And in many times, it's going to be in a very legal way. Let's talk about hire to fire, because in California, there are over 7 million legal cases that are filed on a yearly basis. And why is that important to you? Because in all of America, there's only 350,000 federal cases that are filed on a yearly basis. So in California, there are a lot of cases that are being filed. And I guess the question ultimately would be, well, how many of those are actually employment cases? And those are half of the cases out of the over 7 million cases that are filed on a yearly basis are employment cases. And employment cases are inherently very difficult. Employment cases, in my opinion, are no different than family law cases. Why? Because employees as well as employers spend the best part of their day in the business. So basically what you do after you work is you go home, maybe spend 2 to 3 hours, watch a little bit of TV, watch news, and you go to bed. You don't spend that much quality time with your family, and that's a reality. Well, employees feel in many ways that they've given their best part of their day to the employer. Well, the employer is the same way. The employer also feels that they've given the best of their day to their employee. I remember when I first started, over 15 years ago, I didn't have any business, meaning that I didn't have any clients. I remember one of the first employees that I had, I was so happy and I wanted to treat her so well. And as I continued to grow and I had more employees, I would have to go out and I'd buy dinner for them. And they would always ask me, well, aren't you hungry? I'd say, I'm not hungry. The reality of the situation is I didn't have any money for dinner. So all I could afford was to buy food for my employees. And when my employees didn't look and the food they didn't finish, I would pack it up in a to-go box and I would eat it as an employer. Well, why do I share that with you? I share that with you because in employment cases, both sides feel hurt. Both sides feel wronged. And therefore, employment lawsuits are very contentious. Again, no different than family law cases. But let's get back to the topic of hire to fire. And what that means is, what are going to be the best practices from the inception of someone that's hired all the way to the termination of their relationship, which in my opinion, what I call to be fire, and it's really because it just rhymes, so it's a hire to fire issue. When you hire an employee, it's actually a very simple process. But here's the problem. In California, there's something called the California Wage Theft Act. And what that means is under Labor Code 2810.5, 2810.5, there are certain requirements that are given to the employee that the employer must do. One of them is going to be a written notice that provides the rate of pay, allowances, if any. For example, if there are any meal or lodging allowances, some employees have that. The regular rate of pay that needs to be provided to the employee. If the employer is doing any doing business as, so if they do business in a different name, you also have to provide that as well. The physical address of the employer must be given to the employee. The telephone number of the employer must be given to the employee. The workers' compensation carrier, this is very important in that a lot of employees are miscategorized. And we're going to talk about miscategorization, but a lot of employees are miscategorized. And so one of the requirements under Labor Code 2810.5 is that you provide your workers' compensation insurance over to the employee. In addition, there's also sick leave information that you're provided to the employee as well. Now, why is that important? It's important because a lot of employers in California, small or large, are not complying with Labor Code 2810. And because they're not in compliance with 2810.5, I apologize, what ends up happening is that the employee will end up suing. There may be injunctive relief that occurs. And in California, when an employee sues an employer, they're able to get attorney fees and costs if they win. An employer, on the other hand, is unable to get attorney fees and costs if they win. As a general rule, what they would have to do is they'd have to have a second lawsuit to sue the employee to show that the employee had some type of malice. So in regard to the inception of the employment relationship, you must comply with Labor Code 2810.5. Now, earlier, we talked about the independent contractor and employee relationship. So in California, there's really going to be two main types, categories of workers. One is going to be a regular employee, and a regular employee is subdivided into whether you're exempt or non-exempt employee, and we're going to talk about that. The next issue becomes whether they're an independent contractor. So an independent contractor, as kind of a general rule, is able to control their hours, when they come to work, what they do. It's more based upon contract work. So a lot of times if you hire somebody, for example, to build your roof, if you hire somebody for a specific project, that's going to be an independent contractor. However, in California, after AB 5 and a lot of the rules that ended up passing, the independent contractor relationship is very difficult to have. And so there are two things that I want to share. If you are confused whether you should categorize an employee as an independent contractor, you can just basically Google it online, DE38, Delta Echo 38. And what that's going to do is it's going to give you the information and the different factors that are necessary to determine whether your worker is an independent contractor or whether they're an employee. The second issue is something called DE542, Delta Echo 542. And what is that? DE542 is a form that you file with the state of California. And you file that form with the state of California if you pay an independent contractor over $600. $600. Now, why is that important to you? Because we represent both employers and employees. We've done many different types of cases. In misclassification cases, typically the plaintiff will ask the employer, please give me your DE542. And you know what the employer is going to say? I don't even know what a DE542 is. And so it's very important that you speak not only to your HR or your accountant. Many of them don't know about DE542 because they know about federal taxes, but they don't know about state taxes that well. But a DE542 is required as a matter of law so that if you have an independent contractor, when you hire them, you can legally be able to do it. Now, that doesn't mean that if you look at DE38 or DE542 and you file it correctly, they're automatically an independent contractor. It's very important that you categorize correctly. So important that if you intend to hire independent contractors, I do recommend that you speak with an attorney so they can be able to categorize your workers correctly, because most of your workers are going to be regular employees and not independent contractors. Now, one of the wonderful things about coming to America is that opening up a company, super easy. super easy. It's very hard if I wanted to open up a company in China or in Europe. They have a lot of requirements. In the United States, instant, quick. The problem is this: if you're coming to the United States and you're trying to get US citizenship and you end up owing your employees money, or if you end up miscategorizing your employee as an independent contractor, there are statutes out there that make it a misdemeanor. And if you have a crime, you have to explain to immigration that no, I really didn't have any ill intent. But in my opinion, if you're trying to get your US citizenship, why miscategorize your employees? Now, I do want to say this. I do understand why employers and employees may want to be independent contractors, because on both sides, you technically don't have to pay any taxes. The employer doesn't pay any taxes, and the worker, the independent contractor, can assess their tax and almost eliminate their taxes. Because really on a payroll, it's almost 1/3 of an employer's pay is going to taxes, and almost in many ways 10 to 15, 20% of an employee's wage also goes to the state of California. But unfortunately, what ends up happening is that when an employer says, but the employee wanted me to pay them in cash, the employee didn't want taxes, the employee essentially wanted to be an independent contractor and get benefits from the government. That occurs all the time. But unfortunately, when there's a termination of the relationship, the employee will always say that they were forced to be an independent contractor, they didn't want to be an independent contractor, and therefore the employer will lose. Now, in terms of paying part check and part cash, does that happen? That happens all the time. We have many restaurants, even mainstream restaurants, that pay half check and half cash. And they do it because the employee requests it. My recommendation is to document all of that information. My recommendation is to not avoid the situation, because in the event of a dispute, your documentation is going to control.